dealing with some important definitions in judiciary's exams point of view. And the first definition is where decree has been defined. So decree is a formal expression with regard to adjudication. Uh, Adjudication is where a judge applies his judicial mind, and that application of judicial mind conclusively determines the rights of the parties involved in the case. So, rights of the parties may be with regard to all or any of the matter that is in controversy. Only because there is a controversy, parties are approaching courts, right? So, where judge applies his judicial mind and makes an adjudication, that in turn conclusively determines the rights of parties with regard to all or any part of such matter that is in controversy is called as a decree. A decree could be both preliminary or final. As we already discussed, adjudication is where judge applies his judicial mind and determines a particular case. So decree, it is necessary that we have a clear distinction between a decree and an order. Both are not similar. So we'll have some conversation with regard to distinction between an order and a decree. So decree is where substantial rights of parties are decided, which does not include interlocutory applications. In interlocutory applications, no substantive rights are generally decided. So dismiss for default is not a decree that has been provided under the section itself, and these are some general points that we have to read with decree. So all decrees are appealable. Beg your pardon. So all decrees are appealable. That is provided under section 96. And that is really important to note. So orders are not generally appealable, but all decrees are appealable, right? So we can make this distinction on these small grounds, like decree is generally appealable, but orders are not. So when a decree has been pronounced or given by an incompetent court, that is not a decree. That is a nullity decree. Does not have any value because it has been pronounced or given by a court of incompetent jurisdiction, right? So what is decree and what not a decree? Um so generally, dismissal for default is not a decree, and there are some orders that are deemed to be a decree, right? They are generally, in their essence, they are orders, but under the eyes of law, they'll be deemed as a decree. So that is rejection of plaint, not a returning of plaint, but rejection of plaint. People tend to make mistakes here. They used to get confused with returning of plaint. It is not returning of plaint; it's rejection of plaint. So when a plaint is being rejected, then it shall be deemed as a decree. And any question relating to restitution of conjugal rights, that is not an order, that is a decree. And there could be two decrees in one case itself, that is preliminary decree and final decree. So we can see such scenarios in partition suits and mortgage suits. For example, in partition suit, initially the court decides upon whether a person is entitled to any shares or not. That could be a preliminary decree. And if if a person is entitled to a share, then how such um, how such shares will be divided with regard to the boundaries of the property, that will be final decree as well. So in a case there could be two decrees as well, that is preliminary and final. And in some cases, final decrees, there could be multiple final decrees in some cases as well. And as per section 97, when an appeal is when appeal against final decree has been sought and preliminary decree appeal has not been sought, when in a case there are two decrees, that is preliminary decree and final decree. When a person directly appeals to final decree, then he cannot seek appeal for preliminary decree, because uh, final decree in itself is directly related to preliminary decree. Only um, via preliminary decree, final decree is being pronounced or given. So when you directly go and appeal against the final decree, there is no need to appeal for preliminary decree, right? And therefore, if a person appeals against the final decree, he does not have right to appeal against preliminary decree. This could be slightly confusing, but just take a read, just have read, and you're good to go. So there is another concept called composite decree. Composite decree is nothing but it is a combination of both preliminary decree as well as final decree. That is uh, composite decree. Yeah. If in case when a case is relating to wrongful possession, so in such case there could be composite decree. That is in preliminary decree possession, a court may order a person to transfer the possession, that see, you're in wrongful possession, you have to transfer possession to the actual owner, right? The court may pronounce such preliminary decrees. And and the final decree is about estimation of mean profit. That is, in the sense, the court has given an order, a decree, uh, saying that you have to transfer the position, but the court also makes another decree for estimation of mean profit. So you have been in wrongful possession over the years, right? So you would have earned some profit out of it, and the court makes a commission on orders a few people to estimate for mean profit. So that could be a final decree. So a combination of preliminary decree and a final decree is a composite decree. Section 2 clause 12 deals with mean profit. So mean profit is nothing but when a person is in wrongful possession, he receives some profits out of such property that he is not entitled to. So it does not only include profit, but it will also include interest, right? That is arising out of such property. Uh, so he have to hand over the possession to the actual owner, as well as the profit that he has made out of such property over the years. So so the profits, net profits, include the profits that has been actually received by the person who is in wrongful possession, as well as the profits that he might have received if he was in uh, if he was in uh, ordinary diligence, he might have earned, right? So he has a property now. He has not rented out the property. He has just locked the doors and he just went somewhere. But he has the possession, that too wrongful possession. So he might have rented out such property and he would have earned some money out of it. So even if he did not do so, he will have to compensate. He will have to provide such profit, such estimated profits, though he has not rented out, because in ordinary due diligence he might have received such profits, right? It will also be included in mean profit. And it does not include improvements made by him. So while in possession of in such wrongful possession, if he has made some profits, if he has made some improvements by himself by using his money, then such money will not be included. Such could be made as deductions uh, in mean profit. The deductions includes taxes that he had paid to the government, for example, revenue taxes that he had paid when he is in wrongful possession, and cost of cultivation in case of it being an agricultural land. So revenue taxes are paid, so those will be deducted from the profits, because if even the person, the actual owner, was there in the property, he should have actually paid such taxes to the government. So uh, nobody is being missed here. So because when the actual owner will be there in the property, he will have to pay mandatorily those taxes, and therefore it will not come under the profits. So the taxes will be excluded out of the property, and adjustments will be made with regard to such deductions, and only then mean profit will be estimated. So now we'll deal with section 2 clause 14, that is order. So order is nothing but which is not a decree. So generally it is also a formal expression. So decree is also a formal expression, and order is also a formal expression. But an order is something which is not a decree. So an order of abatement of suit, and an order holding an appeal not maintainable can be construed as a decree, and those are given under this section. And so if any certificate that has been issued by the court, it is a certificate. It is neither a decree nor an order. So who who are public officers? A clear-cut definition has been provided, but it's a bit lengthy. I would urge you guys to look into this particular section, which is really important. So it is provided under section 2 clause 17. So public officer means a person falling under any of the following descriptions, namely a judge, a member who belongs to all India service, that is to say IAS, IPS officers, and every commissioned or gazetted officers who are employed in naval, military, or air, right? So every officer of court of justice whose duty is to investigate and make a report in matter relating to fact or law, and used to authenticate and keep documents, and take charge of or dispose of any property or execute in any judicial process, right? And he will also administer oath. He will also interprets or um, yeah, and any person who is authorized by the court of justice to perform such any other duty, and he is authorized by the court of justice to perform such duties. And any person who is empowered to make confinements, right, they will also fall under this public officer definition. And every officer in government whose duty is to prevent offences, give information, protect public health, safety, conveyance, yeah, public safety. When it comes to public safety, food safety officers will also be included in this definition. And every officer whose duty is to uh, take and receive any property on behalf of government, right, and can make survey assessments and contract behalf of government, execute any revenue process, investigate, make report, right, authenticate, and prevent the infractions of any law, and he protects the pecuniary interest of the government, etc. And every officer who is paid by the government, that is remunerated by fees or commission in performance of his public duty. So this is a broad definition. We can decode words and we can understand this definition, public officer. And under section 3, subordination of court is stated. And uh, this is a particular chart that I came with. So Supreme Court on top, and um, High Court is Supreme Court subordinate at state level. And at state level, High Court is the top court, and under that, it is generally divided into metropolitan courts. Now, metropolitan courts have been removed in Bharatiya Nagarik Suraksha Sanhita, and we only have uh, normal courts functioning. So, in cases of in metropolitan courts, we have city civil courts and court of small causes as subordinate courts to the High Court. And in case of district and sessions, it is further divided into civil and criminal. Here, in terms of civil, district judge tops the position. Underneath that, subcourt will come. Underneath subcourt, principal junior civil judge court and munsif comes at the bottom. And in terms of criminal cases, sessions judge tops the position, and underneath him, uh, chief judicial magistrate, and under that judicial magistrate first class, under that second class judicial magistrate second class bottoms the table. And decree holder is defined under section 2 clause 3. So decree holder is any person in whose favor a decree has been given. So it is not necessary that decree holder should be the party to the case. It may also include the third party. So generally, in favor of whom execution can be made. For example, even legal representative can come under the definition of decree holder. And the definition for foreign court is given under section 2 clause 5. That is any court that is situated outside India and it is not established under the authority of central government. It is really important to know this. And that is foreign court for you. And what is foreign judgment is provided under section 2 clause 6. And foreign judgment is a judgment that is provided by foreign courts. Under section 2 clause 8, it defines who is a judge. Judge is simply a presiding officer of a civil court. Under section 2 clause 9, so these are important definitions. If you want to read all the definitions, I would urge you guys to open up the barrats and read. These are only important definitions in terms of judiciary exam point of view. So section 2 clause 9 deals with judgment. So judgment is a statement. It is not a formal expression, but a statement that is given by a judge on the grounds of decree. So for the grounds of decree, it is provided under judgment. So only upon such grounds decree is usually drawn, right? So what are the contents of judgment? So judgment contains initially concise statement of facts, points for determination, and decision will be given in a judgment, and reason for such decision. It will also be there in judgment. And in case of judgment writing, when it comes to court of small causes, in judgment it is sufficient to have only points of determination along with the decision. So section 2 clause 10 deals with who is a judgment debtor. So judgment debtor, in the negative sense, he is a person against whom decree is passed. So against whom order is capable of execution. It is as simple as that. And under section 2 clause 11, who is a legal representative is given. So legal representative in the eyes of law. So it is really important that we make a distinction between legal representative and legal hire. So legal representative is a wider sense. It includes legal hires as well, others as well, who may uh, sue in representative capacity on behalf of a particular person. So any person who is a representative law, representative of the estate of a deceased person. So if any person is there, his estate will be represented by someone else in his absence, then such person will be a legal representative. And legal representatives are usually need not be in possession of the property. Who does not, who will be included and who will not be included, that is provided here. So who will not be included under the ambit of legal representative? It is really important. This whole section, that is the definition itself, is really important in exam point of view. So these are not included within the ambit of legal representative: trespasser, creditor, official assignee, succeeding trustee, and receiver appointed by the court. So these will not be coming under the definition of legal representative. Legal representative are as follows. For example, intermediaries, for example, intermediaries in the sense tenants will come, and those who can sue in representative capacity. So they will also be coming under the ambit of legal representative. So these are some of the important definitions in with regard to judiciary exam point of view. Yeah, hope you enjoyed this video.